Hello and welcome to the latest in the Fenwick Elliott series of webinars. My name is Jeremy Glover and I'm a partner here at Fenwick Elliott. And today, I think for the first time, we're running a follow-up webinar. Our webinar on this topic back in June has proven to be one of our most popular, both in terms of attendees and also follow-up views on the Fenwick Elliott YouTube channel. So we thought we should run a part two. Now, no doubt much of that success is due to the calibre of my two co-speakers. Lynne McCafferty, a QC at Four Pump Court, obviously greatly experienced in all aspects of construction or at home and abroad. She's been involved in the Grenfell Tower public inquiry. Lynne has been described in the latest legal directories as being reassuringly direct with her views, as being someone who doesn't sit on the fence, who is focused yet ruthless in cross-examination. George Taft, the Managing Director at Secretariat, is equally widely experienced across the board. He's highlighted as a global leader in his field by all the directories. He's worked on both sides of the fence for contractors and employers, and he's worked on many major projects globally, including the Panama Canal expansion and the Chernobyl New Safe Confinement project. So before we get underway, our usual reminder, there's a question box. Please feel free to submit your questions. Questions will be asked anonymously at the end. So what are we going to be talking about today? Well, I'll give you a brief recap on what we were talking about back in June. We'll look at one or two new developments, and then Lynne will be looking at drafting witness evidence. George will be talking about how you get the best out of your quantum expert, something I'm particularly interested in. And then we'll give you some tips for drafting your claims, and there's going to be time for asking some questions too. I should also say that one issue that the three of us are very much alive to, particularly as restrictions are being reimposed across many parts of the world, is that whilst we're talking today about the impact of COVID-19 on construction claims, in reality, I mean, the chief impact of COVID-19 is the effect it has on people's health, and that can include serious impacts on mental health, anxiety through job losses, restrictions on movement, etc. And our focus today doesn't make light of the gravity of those impacts. We're considering here what might be thought of as economic impacts for the construction industry. That should be borne in mind, of course, that those impacts ultimately affects people's livelihoods too. But with that in mind, we thought it'd be sensible to provide a brief recap of what we were discussing in June. And we were looking at the essential elements of what makes up a claim, the four key elements: cause, effect, entitlement, substantiation. And I think our point is, now you all know this, but time and time again, the three of us see claims which don't actually do this. All they do is tell the story. They set out what happened. They say whose fault it was. But so what? From the point of view of a tribunal, a dispute board, an adjudicator, it's not enough. You've got to look, you've got to link cause and effect. You've got to look at the contract to see where your entitlement flows from. And you've got to substantiate these points. You've got to prove that the statements made, the calculations your expert has set out, and the things that you include in your claim are actually true. And substantiation can usually be obtained from, or the best place you can get substantiation from, is your project records. Now, you're a claimant, you're bringing a claim. The burden of proof is on you to prove what you're saying is actually true on the balance of probabilities, and contemporaneous records are the best form of evidence in doing this. The reports of delay and quantum experts, they're only as good as the evidence you provide them with. Very important to remember that. And back in June, one of the cases we looked at a good example. We had looked at a case of Australian case, in fact, of White and PBS. And that was all about delays to the construction of sewer tunnels. And what the judge said, what the judge was interested in, was the way to determine the matter, and he was to actually pay close attention to the facts, what actually happened. And he wanted to assess whether White was able to prove on the probabilities that the delays here to an underboring tunnelling solution delayed the project as a whole. And what the judge focused on, and this is one of the key lessons that we learned in June from the White case, was the importance of the site diary. Now, in the White case, the importance of the site diary was actually what it didn't say. It didn't provide any evidence that White was actually being delayed by the underboring tunnelling solution. So it's good top tip: establish and maintain a detailed site diary or record. It's not enough to say who's on site, but what are they doing? Where are they doing it? If there are hold-ups to projects, what are the issues that are there? You want keeping records, keep emails, keep diaries. And why I say it's not necessarily enough to keep a record of who is on site, because that's the basic site data, the basic timesheet data. And in the last couple of months, there's been a case before the TCC in the UK, which focused on site data, and that's data in the form of attendance data, turnstile information about who was on site. Now, that's all well and good, but that has its limits too. Now, here in the case, the judge said, well, timesheets, they're the best evidence of the hours that were worked by the contractor. Interestingly, the turnstile data was thought to be inaccurate. There were people who worked on other parts of the project who didn't actually go through the turnstiles. They weren't being recorded. And so therefore there was an agreement between the parties that the turnstile data was probably inaccurate, so they wouldn't bear it in mind. And so they'd value the labour against the timesheets, but they'd check it against biometric data, with the fingerprint evidence and the like. It's not quite got to the stage where everyone is actually going to be microchipped. I mean, hopefully that's a sort of science fiction feature film too far. But you've got to use the best information that you have available. So the judge is saying, well, a countersigned timesheet, it's conclusive, it's almost conclusive, it's the best primary evidence we have. So if you're an engineer, you're an employer's rep, you're an employer, and you're being asked to countersign those timesheets, think about what you're doing. You're verifying the records. And if you're going to, like the parties here, if you're going to agree how you record information, and the SCL delay and disruption protocol encourages you to do that, record it. I'm a lawyer. I'm going to say that. Record it clearly so that people understand, so you don't end up before a judge or an adjudicator arguing about what the agreement says. But also think about what a timesheet actually does. The judge here said it doesn't give an indication of what the people on site were doing during the hours for which payment is claimed. Now, if you are an employer, say, and you're saying, well, there's a loss of productivity, people are leaving site too early, or they're spending too long on breaks, a simple timesheet isn't going to demonstrate that. And it's actually not very helpful to you because you're actually trying to prove a negative. So you might need to think about what evidence you need. I mean, if you're an employer and you're relying on an employer's rep, how are they recording progress? What are they putting in their notebook? Because timesheets only go so far. There's a case from about, I don't know, 5-6 years ago, Van Oord and Oilseeds. And one of the issues there was that they were trying to make a claim for standing time. But what the records didn't do was they didn't show plants or people standing around doing nothing. And that meant the judges said was a complete lack of credibility in the cases that was being put forward. And that means sometimes you need witness evidence. Maybe it reinforces the site data and site documentation, or maybe it sort of plugs a gap. And witness evidence is something that Lynne is going to provide a few tips on over the next few minutes.
Thanks very much, Jeremy, and good afternoon, everybody. Yes, I'm going to focus in the first part of my talk on drafting witness statements. So you've got your site diary, you've collated all your timesheets together, and the next stage then is to interview the people that were involved in the project to get their evidence together. Now, the purpose of witness statements can differ depending on the forum in which they're being used. So, for example, in the case of litigation, unless the case settles in advance of the trial, then those witness statements are going to stand as the witnesses' evidence in chief at trial, and they're going to be tested under cross-examination. Whereas, of course, if you're producing witness statements for an adjudication proceeding, then there may be an oral hearing or there may not, but it's really only in the biggest of adjudications that the witness statement is going to be tested under questioning. But one thing that witness statements share, whether it's in adjudication or litigation, is that the purpose of them is to set out the evidence on which you're going to rely in order to explain to an adjudicator or a judge why you're in the right and to convince them of why you're in the right. But it's not just the judge or the adjudicator who is going to be the reader of these witness statements. They're also serving another function, which is to set out your case to the other side. Now, in litigation, one of the purposes, essentially, of a witness statement, at the early stage at least, is to show the other side that you have strength in your evidential case. And you would hope that that might lead on to settlement before you get to trial. But similarly with adjudication, there you're trying to show the other side that you have a strong basis for your claim, so that if the adjudication decision goes your way, they're more likely to abide by it and less likely to try to take the risk of testing it in court afterwards. So there are a few different readers of your witness statements that you have to hold in mind. Of course, all of this will only work if your witness statements are both credible and authentic. And as we're going to come on to see, one big problem in this area is that often judges, adjudicators, lawyers on the other side have a sense that witness statements are not always entirely reliable or an entirely accurate account of what went on. So what can you do to show that your witness statements are both credible and authentic? Well, one thing is to ensure that your witness statements, together with your contemporaneous documents, are the starting point of putting together your case strategy. What can sometimes happen is that the lawyers have a sense of what the case is, and they then try to retrofit the witness statements to fit that. And that's not the way to go about it. That's the wrong way around. What you need to do is establish what your witnesses can say, what you can and can't prove. And that will then guide where you go with your case strategy and the areas that you want to focus on and what you will be able to show the adjudicator or the judge. The building blocks that you need, the contemporaneous documents, the witness statements and the expert reports, which George is going to come on to talk about, are the essential elements that will enable you to prove your claim. So no matter how good your referral notice or your claim document might be, you're not going to convince the judge or the arbitrator or the adjudicator unless you have those building blocks in place. Now, what I'm going to do as a starting point now is to look at the court guidance on witness statements. Now, this provides invaluable pointers, both for court litigation, but also for adjudication and how you can make your witness statements credible. And I'm going to come on to look at also some changes that are going to be made to the rules and witness statements in the near future. So what I've done in this slide is I've really just distilled the main overarching principles that apply to witness statements, both in the civil procedure rules and also in the various court guides, the commercial court guide, the TCC guide. And really, they're all quite consistent in the approach that they take to these overarching principles. And in Practice Direction 32 and in the court guides, what they say here is that, sorry, I've come on one slide too many. What they say, oops, there we go, I've got it now. What they say consistently is things like the witness statements should be in the witness's own words, it's improper to put pressure on the witness and so on. Now, all of these points that are on this slide may seem very obvious and may seem common sense, but what's emerged is that these rules are often broken. And this has become such a concern that the business and property courts, so the TCC, the commercial court and the Chancery Court, set up a witness evidence working group to look into the rules and witness statements and the use to which witness statements are put. And I'm going to come back to this slide in a moment, but I thought it might be helpful to look at the concerns and the criticisms that this working group put together, I think it sheds some light on how judges and adjudicators sometimes view witness statements. So I'm going to move on to my next slide. And here you can see what criticisms the working group came up with. Now, it's probably important to explain that the working group consisted of a range of different lawyers. It consisted of judges, barristers and solicitors. And of course, these are the types of people who will often be instructed and nominated as adjudicators in your dispute. And so the way that they view witness statements, it will be very important to your adjudication. And you can see that what they were saying really is quite wide sweeping. They said that a wholesale change in culture was needed. The sorts of criticisms they came up with went right to the heart of the purpose of witness statements. They were saying, for example, that too often the final version of a witness statement didn't reflect the witness's own words, no matter how well intentioned it was, and even if the first draft had reflected the witness's words. And what they expressed concern about was the practice of numerous drafts and iterations of the witness statement going through different people, the witness, the lawyers, and eventually what you end up with, they said, can be an aspirational version of that witness's evidence. They described some witness statements as over-lawyered and over-engineered. And really what you're seeing there is that the evidence has been polished to such an extent that it doesn't really reflect what was going on in the project. It doesn't reflect what that witness then says when they come into the witness box. They also criticised the very process of putting together these statements with various different drafts going through different people, in the sense that that can actually alter a witness's memory. And there was concern that putting lots of documents in front of a witness, if the witness was not involved in creating those documents or didn't see the documents at the time, can actually corrupt the witness's memory. And again, it's not a deliberate process. It's something which can happen unconsciously. If the witness keeps seeing something in a document that lawyers are putting to them, they can start to think, well, this is of course what happened and this is what I remember, even if they actually weren't involved in it at the time. And another big criticism that came out of the working group, and it's something that we've heard about for years that judges really don't like, is witnesses simply paraphrasing or even quoting large sections of contemporaneous documents in their witness statements. And they really don't like that because they always say, well, we can read the documents for ourselves. So in short, what you can see from this slide is that judges, lawyers feel that witness statements are not always reliable or accurate. And that's a huge problem because, of course, the purpose of the witness statement is to explain to the judge or the adjudicator why you're right and to convince them about why you're right. It's part of your building blocks to make your case to the judge or the adjudicator. Now, the outcome of the working group has been some changes and they've introduced a draft practice direction, which is currently being reviewed by the Civil Procedure Rules Committee, but it's very likely to come into effect in April next year. But interestingly, quite a lot of the focus in this practice direction, and also in the appendix to it, which is a guide to best practice, a lot of this actually simply restates the existing rules and tries to bolster those existing rules. And so really what they're trying to do is to get people to comply with the original rules. So I'll come back to look at this practice direction in a moment, but I think it pays to look back at the rules that I set out in the first slide. Now, turning back to this again, the witness statement should be in the witness's own words. Now, I'm sure we've all seen the situation where you receive a beautifully written, eloquent witness statement, which all makes complete sense. Then the witness turns up in the witness box or appears at an adjudication hearing and seems to be a completely different person from the person whose words appeared on paper. And we've all seen that. Now, there's a balance to be struck in capturing the witness's words, not suggesting that your witness statement should be a verbatim record of everything that witness has said and the exact order they said it. Of course, you want it to be concise, it's got to be in a logical order and so on. But what you want to try to do is capture the words, the turns of phrase that the witness has used to describe what was going on. And the reason why that's so important is because judges and adjudicators can tell when a witness statement has a ring of truth about it. But also, the witnesses on the other side, the people who worked with your witness during the project, can tell if this is roughly the way that this witness would articulate it, if this reflects their experience of that witness. And if it's got this ring of truth about it, if it's got credibility, then the other side are more likely to sit up and take notice of it. And also the judge or adjudicator, if they see this witness in person, it will be confirmed that this person is reliable, that this reflects what they've read on paper. But also it guards against the problem that things will later unravel. And that brings me on to the next points which are raised in the court rules, that you have to identify which parts of the statement are from the witness's own knowledge and which parts are either hearsay or their belief. And if it's the latter, you have to identify the source of that. Now, that's often something which witness statements omit to do, and it's so important. Just to give an example of why it's important, say that on a big project there's a site inspection, and the witness statement talks about this site inspection in great detail, describes what everybody looked at, what they saw. The witnesses on the other side say, wait a minute, this witness that's giving this evidence wasn't actually at that site inspection. So where's this all coming from? Now, what's very important is that your witness statement has to set out which aspects the witness actually observed with their own eyes, which they were directly involved in, and which, by contrast, they may have been aware of through a detailed briefing at a meeting. So if your witness wasn't at that site inspection, but did go to the meeting afterwards where the site inspectors gave a really full debrief of what went on, then make sure it's clear in your witness statement that your witness wasn't there, but this is how they became aware of all the different aspects of the site inspection. It's things like that which it help to make sure that your witness statement doesn't unravel once it comes under the scrutiny of a judge or an adjudicator or a cross-examiner. Now, another rule that's important is that witness statements shouldn't just paraphrase at length the documents, and we've seen that came across very clearly in the working group's criticisms. And the reason why that's important is that, say you have an adjudicator who's already read your referral notice and has clicked on the links to all the different documents. If they then read the witness statement that simply regurgitates all of this, their eyes are going to glaze over. What's the point of reading this? They're not really going to take it all in or give it much credence. What your witness statements have to do is to tell the story that doesn't appear in the documents. Fill in those gaps between the documents. So the site diaries and the timesheets that Jeremy talked about at the start of the talk, explain what those people were doing, people whose names appear in the timesheets, explain where they were, why they were in those parts of the project. The site diaries, explain how they came to be put together, what processes you had in place. So all of these things can help to build upon the contemporaneous documents rather than simply repeating what those documents say. Now, another important rule is that witness statements should be factual and they shouldn't stray into argument, submission, opinion. And that's really important, even if your witness has strong opinions and would want to make submissions, you do have to rein them in and keep it factual. You have the chance to make submissions in your referral notice or in your skeleton argument, and that's the place to make them. You want your witness to come across as merely giving a straightforward, factual account of what happened. Now, I promised I would come back to the changes the working group have proposed as a result of their review of the witness evidence. And the result is a new practice direction. It has the snappy title of Practice Direction 57AC. It's likely to come into force in April. Now, the key things to note from it are they've expanded the statement of truth for witness statements, and they're now requiring solicitors certificate of compliance with various different bits of guidance. The appendix to the practice direction is interesting. It's an interesting document which builds on this point I made earlier that the working group were concerned about, which is that witnesses' memories can become tainted by the process, the very process of producing the witness statement. They described the human memory as being malleable, fluid, and there's a very interesting part of the appendix all about that. But really the practical things to take from that are, when you're going through the evidence of the witness, show them the documents they wrote, the documents they received and were involved in to help jog their memory. But don't start showing them a whole load of other documents that they were never involved in at the time, because if that starts to replace their memories of what happened, their own direct first-hand memories, that can make it very difficult for them if they're then challenged on it, because they won't actually recall the detail in the way that they would otherwise. I've also set out the next slide some further points. There's been a few other changes to practice directions on witness statements recently, and these ones are now in force, but I won't go through them in detail. That's really something that you can look at later. And just to tie up the loose end, all the different ends here, I think really the key thing about the witness statements is that it's not an extension of your written submissions. It has a different function. And the key thing is it has to be credible and authentic if you're going to be able to use it to persuade the judge or adjudicator that you're in the right. So I'm going to hand back to George next on expert reports.
Thank you, Lynn. I'm going to look at what is needed from a quantum expert, how this fits into what's needed for a claim submission, and in the light of this, what a quantum expert needs from a client. So my first point is that a case should be built like a pyramid, and this is what I've picked up from lawyers and also tribunals and judges, that we don't want to get this the wrong way around. We don't want to get the cart before the horse. What you should start with is the base of the pyramid, contemporaneous documents forming the base. What does the evidence show? The next layer is everything we've just been talking about, actually, from what Lynn has discussed, witness recollections, because of course the contemporaneous evidence, sometimes there will be gaps or things that are unclear, and so the witness recollections can tie things together and plug in certain gaps, as Jeremy said earlier on. And then finally, forming the top of the pyramid is the expert analysis, which can help pull everything together and present it, and the opinions and the assessments of what the resulting quantum is. So although the expert report is at the top, it is not a substitute for building the case up from the documents and the evidence. We don't want an upside down pyramid. We're in construction. We know that doesn't work. So if the foundation and building blocks of evidence are lacking, the judges and tribunals are unlikely to be persuaded solely by an expert report. It's not enough to have a polished top to the pyramid with little underneath it. That would be more like a house of cards. Just moving on to the next slide. Oops, my apologies. Conversely, if you can show that there were genuine causes giving rises to impacts to the cost, and that the estimate of that cost effect is supportable and realistic, success is of course more likely. So the first point here, scientific precision is impossible, particularly on large complex cases, and it's not needed, and this much was clear, of course, from the well-known Walter Lilly case back in 2012. However, a claimant and its quantum expert must show a real effort to reflect the imprecise, and it is often complicated, but the truth of what happened and the resulting cost impact. But, and this is a big but, however complicated the truth, if the evidence for the cost and the linkage to causes is below a certain standard, if that underlying base we talked about of evidence isn't really there, then honest independent experts are unlikely to be able to help. In fact, Jeremy joked the other day that he always finds it disappointing when it turns out that a quantum expert can't magic up a claim out of thin air. Always, in the light of that, consider your expert's independence and credibility. It's very dangerous as a claimant or the legal team to push the expert, and for an expert to give in and become like the proverbial hired gun that we sometimes hear about, because that can backfire badly. Your expert, of course, the final point I've got here is the subtle difference between opining about the facts, which is dangerous as an expert, as a quantum expert or a delay expert. You're not there to do what the witnesses would do. The witness evidence that Lynne was talking about, they will talk about their recollection of the facts, whereas as a quantum expert, my job will be to look at the facts and then give an opinion based on those facts, but not to start to interpolate and on those facts. I've just referred here to start with, and I remember we touched on this back in the first webinar, balance of probabilities. One doesn't have to prove every cost beyond doubt, but there needs to be sufficient relevant records, and I think the key word is relevant. And this was a point again that Jeremy mentioned earlier on when he was referring to the White versus PBS case. It's one thing to have lots of timesheets, but it doesn't help much if they don't refer to the work activity or the task that forms the subject matter of the claim. So it's important for contractors, for claimants who know that there are events happening out on site, to ensure that personnel are, as they're filling in allocation records and so on, that those are picking up what is relevant, what you know is going to be a matter that is going to have to form a subject of a claim. It's no good having a mountain of records if those records aren't going to pick up the relevant points. Back in June, in the first webinar, I referred to the example of downtime due to tasks such as hand washing, just reflecting on the COVID case. And it's for tasks of a repetitive nature, when we think about some of these tasks that are ongoing, one doesn't have to engage in an exhaustive task of finding all the records, because that could just be entirely disproportionate. And in that case, a sample approach could be taken to analysing what the records show for a range or a given period, and you could take some other periods and then see what the costs are and see whether it's possible to extrapolate from that. So just thinking a bit further about this sample process, the critical thing with sampling is that it must be representative, and the type of the impact must be something, the costs and the resources, it must be something that is recurring, that will replicate if it's something from the sampling that is then going to be extrapolated. So the amount of sampling, it must be sufficient, but it must be proportionate. So if it is a particular task, for example, where the resources engaged on it can be seen to just recur and replicate from one period to the next, then clearly one shouldn't have to keep on doing sampling if it's just going to keep proving the same thing. It will become disproportionate. And you do need to consider changes across time. When you think about the course of COVID and the restrictions, it changes. So again, if you're doing samples across time, you can't take one time period and then find a few months later that if restrictions have changed, if guidelines have changed, then it may be that a further analysis will need to be undertaken of that different period. And the final 2 points, that's just restating something that was said that I said in June, that it is a good idea for parties to engage, to look at a method and approach that both parties can agree to, And indeed, of course, there are contracts that specifically look at a prospective approach to valuation, such as the NEC. And again, that is something that it's highly beneficial if an approach can be taken like that to avoiding a more retrospective approach where you're trying to pick it up at a later date. Just a couple of final slides, just thinking about what we've learned from recent months. And this is just certainly what I've picked up from discussions and from what I've seen of construction projects. First of all, the stats will show on lots of construction projects in recent months that there are numbers of personnel that have either tested positive or been subject to a period of isolation due to COVID. And in some cases, this is not just 1% or 2%, it is significant percentages. And of course, for many of us, personnel can often work remotely at a reasonable degree of efficiency, and I'm sure many of us on this webinar today are doing just that. But of course, that's less so for many personnel engaged on the delivery of construction projects. Take, for example, setting out engineers. If you have a significant percentage of setting out engineers that don't make it in at a critical phase of the project, that will have a material impact on the project. And here, don't worry, I won't go through all of these, otherwise I'll be here far too long. Here's just some further examples. And I think the important thing is you glance down this list. These are issues that fluctuate. If you think back in late summer, restrictions were lifting and progress would have been less impacted, but then of course it suddenly changed. And of course, when the changes have occurred to restrictions, it's something that often has been done at short notice. So it's not something that contractors and subcontractors will have been able to plan for. And so as you read down this list, you can imagine the effect. And of course, and it varies a lot from one supplier to another. In some cases, there will have been an impact on material supplies, but in other cases not. And so each of these effects, you can see at the bottom there, I've just made a note that there are impacts at a micro level on direct costs, but there are also impacts on that could take place on the program, which will then have an effect on time-related costs of the project, and that all has to be considered. And then the final point, which I've referred to as counterintuitive, is that, of course, there are some circumstances where a project might not have, there might be an impact that's not adverse. For example, if it's a project that has suffered less constraints due to traffic issues or travel times, there are some cases where there can be some benefit, and so that might need to form part of what's considered as well. That's the finish of my first section. I'll be coming back at the end just with a few more comments on looking ahead. Thank you.
Excellent. Thank you, George. And another example of the type of issues you're talking about at the end might be fit-out projects where the contractors don't have to work around other people who are in the building. But Lynn, we've just got time for some of your top tips for drafting your claim or referral notice.
Yes, thank you, Jeremy. So you've got your contemporaneous documents, your witness statements and your expert report. So now is the time you want to synthesize all this material together in order to produce your referral notice or your claim document. And I've set out in this first slide a checklist of things that you will need to include and make sure that you've covered off. Of course, you've got to make sure you've explained the contractual and legal basis of your claim, as Jeremy mentioned earlier on. And a key thing that you need to do in this document is to set out the factual basis for your claim as well. And this is where you have an opportunity at this point to put forward the documents that you rely upon. And you may want to summarise the key project correspondence here rather than in your witness statements, as we've already discussed. But one thing that's really important in this document is it's got to be readable and accessible, and it's got to enable the adjudicator to navigate their way through the evidence that you've collated in order to support your claim. So you can do that by including cross-references to the paginated bundle. if you're using an electronic bundle, then you could consider using hyperlinks to the documents that you're referring to. And what you really want the adjudicator to do is to go in and look at these site diaries, timesheets and so on that you've carefully maintained and put together. And if you can make his or her life easier by including hyperlinks or references so that they can do that, then all the better. And it's all about helping them navigate their way through all of this documentation. Of course, in the referral notice or the claim document, you have an opportunity to make submissions, and this is where you can bring in the legal argument, submissions and so on. I've suggested in the slides that you want to maintain the moral high ground, and what I mean by that really is the tone of the document. I often see adjudication submissions which are full of very colourful language, very emotive language, and when I've sat as an adjudicator, I've not found that to be a very effective or persuasive way to go about doing it. I think it's better for your adjudication documents to keep a professional tone, a straight down the line kind of tone, so that you are really enforcing the fact that you're right, that your documentation supports your case, and that you don't need to fall back on florid language in order to make your point. And again, it all comes down to using the evidence to support your claim and showing that it's founded on a strong basis. You also might want to preempt some points that you know are likely to come out in the response. You want to be careful, of course, not to hand any arguments to the other side that they haven't thought of themselves. But if they've already made points in correspondence and you know that that's something they're going to come to in their response, then you can use the opportunity in the referral notice to nip those in the bud. And finally, it's extremely important, of course, that you set out the what you're claiming, the redress that you're claiming in detail, because of course with adjudication that can really set the parameters of what you're entitled to recover. All of this, of course, only works if you have a well structured and well put together bundle of evidence behind it. And all of this is very obvious stuff, but it's got to be paginated, whether it's electronic or paper. Pagination and structuring is very important. So having tabs, whether they're physical tabs or electronic tabs, so that if the adjudicator does want to go into the bundle and have a look for it, for things, or for just to have a look around what's in there, that they're able to navigate it themselves without having to rely upon the referral notice to do that. And I've set out some of the things that you need to include there. But really, the key thing about this is it's all about helping the adjudicator to make sense of the materials. No matter how good or how well written your referral notice is, the adjudicator wants to see the evidence that's behind it. And if you don't give them the opportunity to navigate the material in an easy way, then they may think this is all about smoke and mirrors. So the key thing is to set out your case, have the cross-references, and ensure the adjudicator can access it easily and efficiently. And that's all I wanted to say on referral notices.
That's excellent. Thank you very much. George, I think you're just going to round things off by looking at what's next for contractors in the current uncertain times.
Yes, and I will try and be very brief because I know time is short. There was an article that Secretariat put out back in September, which considered some points looking ahead, which of course in September we were looking ahead to the next wave, which of course we're now experiencing. And the points that were being considered in that article was the fact that the emergence of COVID, of course, wasn't foreseeable, whereas now, of course, we're all painfully aware of the risk. And so it's something that parties to construction contracts should perhaps consider and acknowledge when they're entering into contracts, the existence of the risk and how it's to be managed. So there were some thoughts that were outlined in terms of measures that employers and tendering contractors might wish to consider when thinking about future events of the nature we've seen. So just very briefly, there we go. And my apologies, there's a time lag on the slides. There are just 4 points here, and very briefly, the first is to define in the contract, you know, whether a wave or a pandemic, to define that as a relevant event or a force majeure event, to define the trigger mechanism. So, for example, you know, one might think, well, at what level does this become an event that falls under this criteria? Well, that's not necessarily an insuperable problem, because think about exceptionally adverse weather conditions. Weather conditions are localized, and a lot of contracts will specify a particular weather station and a particular level of weather condition beyond which in that locality it becomes an event. And so something similar could be considered for the nature of the, you know, when you think about the regional tiered system that we've seen. So that's one point. And a further point might be, when this event is triggered, is whether it's a time impact or a time and money impact. That's another point that the party would consider. The second point is use of a provisional sum, and because of the nature of these issues, it's likely that this could only be regarded as an undefined provisional sum. But again, having that in the contract can enable the management of that risk to be better undertaken. Third point is the considering the use of the contract variation mechanism, and again, one could tailor what is stated about that mechanism in terms of how it is to be valued, and maybe specifying the sorts of records that should be kept. And the final point linking into that is just another proposal that is more often seen in the oil and gas industry, but certainly something that can be considered, is agreement of what I refer to here as liquidated daily rates. So, for example, if there was going to be a suspension period on a contract or a particular section of a contract, one could agree rates, and that's obviously a benefit in terms of, for both parties, that it gives cost certainty to the employer, but more certainty and clarity of revenue to the contractor. That's it. I won't go further in the interest of time, but it's been good to talk through this, and I'm sure there may be some questions if there's time that Jeremy might be able to put to us. Thank you.
Yeah, brilliant. Thank you very much, George. Yeah, we do have time for one or two questions. There's one question that's come in, and it starts, I suppose, as an observation. Everyone talks about the delays that have been because of the pandemic, but what's actually happening is that work that would have been carried out in the spring and summer, perhaps when it was warmer and there were longer daylight hours, now being shifted into the winter months. And I suppose that's a case of how you actually document the delays, in the sense that work that's been carried out more longer on site, there's actually a shorter period to carry it out. And so it's how you quantify the delays and costs that are emerging out of that. I suppose it's one of the effects of the pandemic. Like I say, it's perhaps more of a comment, but I don't know, George, if there's anything you'd want to say about that.
Yeah, it's almost like the reverse of you can have a scenario where a delay on a project would push tasks into a winter period, and that causes additional delay. And in a way, there are circumstances that we've seen here, particularly, as you say, in summer. Not only was there good weather, but there was reduced traffic. So, of course, it might have led to a benefit, which is the reverse of the situation of being pushed into winter that I mentioned. And I suppose the key point is that in assessing the overall cost impact, one needs to look at what the effects really are. So, if in reality, so one shouldn't, for example, assume a certain level of production when assessing a delay, if in fact the actual production that was achieved was better. So I think it would be fair to say that, as I say, if there are certain periods where there has been a better level of production, for example, or some cost reduction that was achieved, then that would have to be reflected. It would be wrong to go and assess the cost as if those effects weren't happening.
Yeah, brilliant. Thank you. I mean, there's been another comment, Lynn, about we've been talking about your tips about the referral notices and the potential differences between smash and grab type adjudications and technical disputes. And I think it's fair you see from smash and grab type adjudication, you would expect the disputes to be much more tightly defined with much fewer documents that are being referred on, because it's fairly simple, straightforward dispute, technical dispute, much more documentation, and potentially witness statements and evidence that you would need to rely upon. But there's been more comment, I think, in particular about what you've been saying about witness statements. And perhaps sort of a thought to leave, and we could sort of as a parting thought. If we were having this conversation in, say, 2 years' time, would we still be using witness statements?
Well, that's a really interesting question, because actually this working group that I talked about, one of the things that they discussed was whether we even need witness statements for court proceedings. And I think some of the participants in the group had kind of rose-coloured views about the way it's done in criminal courts, where you don't have witness statements, you just have longer examination in chief. And judges suggested that what comes out of the examination in chief is much more an accurate picture of the witness's real recollection of events. But I think for the sort of work that we do in the TCC and commercial court and so on, I think it would take ages to get a lot of this evidence out in chief. Obviously, it just would be too expensive to do that. So I think there's definitely a place for witness statements still in court proceedings. For adjudication as well, obviously there can be adjudications where you don't need witness statements because, for example, the sorts of things you mentioned where there's a discrete issue and you can deal with it just on the documents or just with a focused expert report. I think in the bigger adjudications where there's a range of different issues, I think speaking it now as an adjudicator, really, I think it's still really helpful to have evidence that is from the ground, is from people who were involved on the ground on the project, and they can fill in the gaps between the documents, as I mentioned before. They can explain what was really going on, because as we all know, there's often so much happening that is just not reflected in the documentation, and you really need the people who are involved to give you that colour, context, and so on. So I think there's still a place for witness statements, definitely, and I think that's probably still going to be the case for others.
Okay, excellent. Well, thank you both very much indeed for your helpful and very thorough discussion of some of those issues. And I'm sure I'll be inviting you both back early next year for part 3 in our session. But it's just time for me to introduce our next webinar, which will be in 2 weeks' time on 3rd of December. My colleagues Claire King and Rebecca Arder will be looking at NEC target cost contracts. So hopefully you can join us then, 12 noon, 3rd of December 2020. But thank you very much for your time today. Copies of the slides will be made available to everyone who's attended shortly. Thank you very much and goodbye.